do our lecture on copyright, fair use. What is fair use? That's our topic this afternoon. But before we get into that, I just want to talk a little bit about the American Women Writers National Museum, which is sponsoring this event. Women purchased 70% of the books sold in America, and yet there was no national museum to honor our great American women writers. So I established such a museum, and our grand opening was in February. And we honor all American women writers, historical and contemporary. We have something called the 50 State Project. So every month we honor 4 women writers from 4 states. And this month in November, we're honoring women writers from South Carolina, South Dakota, Tennessee, and Texas. I won't go into these great women writers because we have a speaker today who we are anxious to get to. And I want to introduce our great speaker. I have to find my intro. Christian, could you turn it off for just one? Rob Kasunic will explain the fair use doctrine, which allows limited use of the work of others for specified purposes that would not be copyright infringement. Kasunic holds the BA in Political Science from Columbia University and a JD degree from the University of Baltimore. He has, hi Nick, come on in. If you want some lunch, go get lunch.
I'm fine.
Okay. And he has served as co-chair of the Washington, D.C. chapter of the Copyright Society of the USA. Sit up here, Nick. Come on, sit by me. His publications and scholarly work cover 2 pages, single space, so I can't read all those or that would take up all the time, but suffice it to say, he's the Deputy Counsel of the Copyright Office, and he has an extremely distinguished background in writing and in scholarly work. So, with no further ado.
Thank you. Well, I am going to be ad-libbing today, and I mostly want to talk about things that you might be interested in. I can talk all day about fair use issues, but I think probably it's best to start out first just a little background on copyright law, so we're all clear about some of the copyright basics and what the purpose of copyright is. To begin with, the basis for copyright protection in the Constitution is to encourage creativity. So the goal of copyright is a means to an end, to provide protection and exclusive rights to authors in order to encourage them to create copyrighted works. And we've gone through a number of different statutes that are based on that copyright clause, empowering Congress to create copyright laws, but are currently living under the 1976 Copyright Act, which establishes copyright protection quite easily. That all that has to occur is that there has to be an original work of authorship that's fixed in some tangible form. So in the case of novels or works like that, virtually every novel or even various iterations of the novel as it's being written, once it's fixed in a tangible form and is original, meaning not copied from someone else, is protected by federal copyright law. I should put in a plug, although copyright protection is automatic, there are still incentives in the law that encourage people to register their works and register them with the Copyright Office in a timely manner. And some of the most significant benefits of copyright registration are that there is the availability of additional damages if you bring a copyright infringement suit, the ability to recover attorney's fees if you have to go to court, and significantly too, that a copyright registration is required before you can actually enforce your copyright. So in order to get into federal court, you have to have a copyright registration. You can do that at any time prior to filing the lawsuit, but if you do it early, then the opportunities or the benefits the remedies that would be available in terms of those statutory damages or attorney's fees would also be available when you bring the suit. So copyright protection is easy to obtain, and registration provides some additional benefits, but immediately on the fixation, then the copyright is a bundle of exclusive rights. That there is the right that we commonly think about of copying or reproducing the work. And as I'll talk about a little bit more, particularly as we get to fair use, reproduction can happen in different ways. It can happen either literal reproduction, where somebody actually takes words or paragraphs or pages from text and copies it. But there's also non-literal reproduction, where someone takes a storyline or a plot and uses that and uses too much or protectable amounts of that work. And that's another area I think it's important to talk about, and I'll get into a little bit with the doctrine of the idea of expression dichotomy, but let me come back to that. So literal reproduction and non-literal reproduction are protected under that reproduction right. There's also a separate right for the derivative right, or the adaptation right, that would protect against adaptations that could be created from an original work. For instance, in the case of a novel, an English novel, translation into another language would be a derivative or adaptation of that work. Turning that novel into a motion picture would be an adaptation. And anything that would be a expected or reasonably expected market for that, further market for that work could fall into that kind of derivative uses of the work itself. And certainly, the more popular the novel, when you think of something like a Harry Potter novel, where there also becomes a motion picture, the derivative uses that kind of in terms of merchandising and all the other artifacts that can be generated from the characters or the story itself would also be included. There's also a separate right for the distribution to the public. So distributing the work, selling copies of the work, or giving away copies to the work is something that is exclusively an exclusive right of the copyright owner, and the copyright owner is authorized to grant or authorize others to distribute copies of the work. And that's, I think, we're seeing in the digital age, the distribution right, as well as reproduction that's often occurring with digital technologies, are something that are of significant concern to many creators now because of the ease of distribution and reproduction that's occurred. So those are some of the challenges that copyright faces, in that there's no longer the physical items that need to be produced and distributed. It was one thing to go after massive piracy schemes that would, and big operations that would reproduce tangible copies. Now that can be done from anybody's personal computer. So it poses significant challenges and policy questions for copyright moving forward that everyone is struggling with how to deal with some of these new technological issues. In addition to the distribution right, there's also a public performance right and public display right. So those could be, and there are some questions now about where the line is, particularly when we're talking about works that are put online in digital form. To what extent does that constitute a distribution or a public performance of the work? Public performance would be if you're singing a song or playing music to the public or showing a movie, that would constitute public performance. And public display would be showing images or it could even just be displaying text would fall under the public display right. So this bundle of exclusive rights is all of what exists immediately upon fixation of an original work of authorship. And there are various, the difficulty can be what it may be easy to obtain those rights, but sometimes policing those rights and enforcing those rights, which has to be done by the individual. The Copyright Office does not enforce copyrights. Rarely does the government and the Justice Department can bring criminal actions, but that's usually been in the context of massive piracy operations, and seldom will they get involved in any specific, or I'm not aware of specific instances where criminal actions were brought by the Justice Department. So copyright has to be self-enforced, and that involves, there are costs involved with that, but again, there are benefits if there is a timely registration and make some of those issues easier. So those are the basic rights and how copyright is founded, I think, are important to have a sense of before thinking about any of the limitations of the copyright. One thing that I think people sometimes get confused about is the question of copyright infringement versus plagiarism, and that is they're really two different things. And as we talk a little bit about fair use, I think it becomes a little bit clearer that plagiarism really is taking someone else's expression and not crediting them for doing that, for copying, and it's really more of an ethical or a moral type of form of protection, or have those kind of consequences. You often see plagiarism as something that's dealt with very harshly in the context of academic authors, or in some cases the penalties for plagiarism could be more severe than copyright infringement. I don't know of anyone situation where a professor could lose tenure is one way that would occur by plagiarizing, not crediting someone else's work. But just crediting someone else and thereby not plagiarizing, so if you quote from somebody else or use an idea from somebody else and give credit to that, that may satisfy that ethical consideration, but it does not provide necessarily cover for copyright infringement. So just crediting a source is not in and of itself necessarily enough to justify or to indemnify someone from copyright infringement. So for copyright infringement, I guess it's important with each of those exclusive rights, there are going to be different questions that arise in terms of proving whether someone has infringed a work. Most often this comes up in the context of the reproduction right, and it's typically proven by just showing that somebody had access to your work and that they reproduced some substantially similar reproduction of that work, that there's some similarities between the two works, and ultimately that something that was protectable was taken from the original work. Now that raises some issues that were some of the limiting doctrines of copyright, and two of them, probably the most significant ones, are the idea-expression dichotomy and fair use. Both of those two internal doctrines in copyright law have been cited by the Supreme Court as the free speech safeguards within copyright law. So, but for the idea-expression dichotomy and fair use, there could be some problems or some conflict between copyright protection and the First Amendment. So before getting into fair use, the idea-expression dichotomy defines a line between copyright protects original expression of an author or of a creator. It never extends to the ideas underlying that expression. It doesn't extend to facts or discoveries or systems or methods of operation. So this idea-expression dichotomy is something that is always free to be mined by the public from a copyrighted work. You can take the idea that's contained in a work and discuss that or write about that idea without infringing copyright. Problem is exactly where do we draw that line between what is the idea and what is the expression of the idea. And that is one of a much more difficult question and one that courts have struggled with. In fact, one of the famous judge, Judge Learned Hand, had said that that line is difficult, it can't be drawn and never will be, that it really has to be looked at on a case-by-case basis by comparing the works and sort of understanding what constitutes expression. And again, that expression can be the literal words or it can be the storyline. So in the case that Judge Learned Hand made that statement, he was comparing two plays with each other and looking at the overall plot of those plays and the character, and looking at, although there were similarities between the two, looking at whether so much had been taken that it actually infringed the original author's copyright. And in that particular case found that it did not, that it was free to take this generalized storyline about two families and in some ways an example that's been taken is being able to take the basic theme of something of a love story like Romeo and Juliet and being able to take that idea from that and turn it into a West Side Story or another similar kind of work, as long as the particular expression in the original work is not taken. That is one limitation, an important limitation on copyright, that it just protects the expression. In terms of fair use, which is another significant limitation on copyright owners' exclusive rights, it began as a judge-made doctrine. So at the time the statute had exclusive rights in it, but fair use was created as a mechanism to avoid the harsh results that would occur if you applied the statutory language strictly. So it was a way of balancing the interests of the copyright owner and the user. We had case law for many years. The first case involved a biography of George Washington. That was the original work being I think it was about a 10-volume biography of President Washington, and that was later turned into a shorter biography. It was only the second one, it was only 3 volumes. And it had taken from the original biography, and this latter work was to be used in classrooms. So I don't know, classrooms have changed as far as I can see. I don't know 3-volume treatises being used in classrooms much anymore. But in that, what was taken were some of George Washington's letters that were owned by the original author. They had been purchased, and ownership of George Washington's copyright had gone to the original author. And then when this abridgment was done of the work, or shortening of the work, those letters were, some of those letters were used. And in balancing those interests between the two, in that particular, that first fair use case, the court found that too much had been used. It had used entire letters rather than just utilizing particular sections to make a point. But Justice Story, who decided that case, expressed some of the considerations that would go into what later became known as the fair use doctrine. And they are still some of the factors that are used today and that have since been incorporated into the Copyright Act, the 1976 Copyright Act, in Section 107. So we've had the Supreme Court address the issue of fair use a number of times and interpret those factors under the statute, but essentially fair use is a consideration of four factors to determine whether the use is fair. And the four of those that I'll spend a little time talking about each of them is, you first have to look at the purpose and character of the use, and that can be including whether it's for commercial or non-profit uses. The second factor is looking at the nature of the copyrighted work, what type of work is it. The third is the amount and substantiality of the portion used in relation to the original copyrighted work as a whole. And the fourth factor is the effect on the market or potential value of the copyrighted work by the use by the defendant. So those factors are really four different ways of looking at the same question through a different perspective, and to determine whether a particular use is fair. And in part, the reason, the preamble that is in the statute for fair use lists a number of different types of uses that had traditionally been considered fair use. Things like criticism, comment, news reporting, teaching, research and scholarship are all things that were listed by Congress as traditionally having been fair, had been in certain situations been considered to be fair uses. And all of those, if we think about all of those types of uses, really it involves some kind of a socially beneficial use, and also have some relationship with First Amendment values, scholarship, criticism, teaching, news reporting. So at least in terms of its foundations, fair use is squarely centered on these socially beneficial and First Amendment values. And really the intent is to further the purpose of copyright, where you have to go beyond using somebody's idea and actually need to use some particular expression or desire to use some particular expression from another author. Balancing those through those four different factors, what the purpose of your use was, what kind of work were you using it from, how much did you use, and how will your use affect the market for the original work, are all considerations that have to be made. So that's one of the difficulties with fair use, is that people tend to look at fair use as just sort of think, well, from their own perspective, and think, well, I know what I want to do, and I think it's fair to do this. This seems fair to me. I think part of what the factors try and do is have people look at this question from different perspectives. And some have said, the treatise writer on copyright law, Melville Nimmer, had looked at fair use and sort of called it the golden rule of copyright. To do copy from others as you would have them copy from you. And I think it's a good approach to put yourself in the perspective of someone else, and that's been how fair use has been characterized in some ways. Is what would a reasonable copyright owner allow in terms of certain uses from their work? So there are some things that, while we have these factors, and that's the only way that you can analyze whether a particular use is fair or not, and I'll talk a little about how the court has done that in certain situations. There are some things that we do on a recurring basis that only would fall under fair use. There's no specific exemption that would allow a particular use of work. For instance, just simply quoting from someone else in your article or book would, or from another poem or from another novel or someone's speech, that would be involved the reproduction right. It would be reproducing, literal reproduction of somebody else's text. There's no specific limitation in the Copyright Act that exempts the use of a quotation. So some laws have in other countries have a concept of fair dealing that actually specify and allow uses of certain amounts of works. U.S. law does not have anything like a exemption like that. The courts have imposed or have applied a de minimis test in certain situations where there's a very small amount used, or it's used very tangentially in another work that could be result in or indemnify use in some cases, but in many cases a quotation will be more than a de minimis amount. So the only way under the law that we would get that being an authorized or allowed to use that quotation would be under fair use. And that's something that I don't think most people will go through every time they're going to use a quotation from somebody else. They're not going to generally go through those 4 factors in their head. I don't know if anyone else besides copyright lawyers do that. But if we go through the factors, that if you see why it has a basis there, that if you're using, and it probably helps to think about each of the factors a little more and why that's so. So as I mentioned, when in looking at the purpose and character of the use, the first factor, the touchstone of that factor has become whether, and a lot of this goes back to the original decision by Justice Story, is was the purpose of the use for some transformative purpose? Were you using it for some new purpose or a different meaning for that work or that amount that was used? Or were you using it just merely to avoid the drudgery of coming up with something new? That was a line from Justice Souter in the most recent fair use case. So quotation, there are some questions that come up. Does there have to be do you have to have a purpose? Does there have to be a need to use someone else's expression in your work? And there are some cases that would tend to suggest perhaps so, but I think that that's probably not the best way to look at it, because you have to look at every fair use case differently. But one of the recent fair use cases that was decided had to do with parody. And parody, where you're making fun of another work, obviously you have to, there is a necessity to conjure up the work you're making fun of, or the parody would not work very well. So looking at fair use in that particular context, you could see that there is some necessity for the use. But in the context of quotation, that necessity is far less clear. I think that in some cases, quotations will be used for flavoring, or for additional support for a point, or from another perspective of some issue that is being discussed. And so I think that it goes too far to say that fair use or the purpose and character, there has to be some showing that you needed to be able to use expression, otherwise it was inappropriate. First of all, that's only the consideration under the first factor, but even under the first factor, I think we want enough breathing room that certain reasonable uses of somebody else's expression in a certain context may be acceptable. So the commercial, non-commercial purpose is also something that the courts have focused on, and this was something in particular that was given to provide additional reassurance to educators, and that in the nonprofit educational setting that would be favorable under the first factor for fair use. But certainly many uses are going to be commercial, and the real question is going to be, was the use transformative in some way? Was it serving some socially beneficial purpose or some new and different purpose, or giving some new and different meaning to that original work? Under the second factor, the nature of the copyrighted work, the courts typically look at just a couple things. One would be whether the work that is the expression that's being taken from is primarily factual or primarily more on the creative end of the spectrum. So this consideration would be that factual works like a news article would be more susceptible to utilizing the expression in that than a core creative work like a novel. So that's one consideration under the nature of the copyrighted work, and it really is a spectrum between these poles of factual or creative, and many things fall somewhere in the middle. For instance, I think courts are struggling with trying to understand where photographs fall on that spectrum. Are photographs factual, or are they creative? Or they're probably, it depends on what the photograph is, and it's probably going to fall somewhere closer to the center, or maybe even more towards the factual side in some cases. But courts are struggling with that issue. The other critical consideration that courts have emphasized under the second factor, and this is something that I personally thought a lot about because it was the subject of one of my articles. Since courts think so little about the second factor, I tried to offer a host of other things courts could look at under the nature of the copyrighted work, because thinking of the nature of something seems like such a broad term and open to so many different considerations, yet we see courts only looking at, really, is it factual or creative, or is it published or unpublished? That's the other two considerations that courts will look at. Unfortunately, I don't think any judges have read my article yet, so haven't found any evidence of that. But the unpublished and published distinction is something that the Supreme Court did weigh heavily on in the case brought by Harper and Row against The Nation magazine, and that involved the President Ford's autobiography, and at a time when it was unpublished and when he had a contract for serialization rights to Time magazine, where they were going to publish excerpts of it prior to it being published. And somehow The Nation got hold of a copy of the unpublished manuscript. The court called it a purloined copy of the work, and it seemed to suggest you had an image of people in black clothes and scurrying around in the dark with this copy. But the court found that when The Nation published what was really a very small amount, it was less than 1% of the total from President Ford's autobiography. When they did that, and it had an effect on the market, Time canceled its contract. When The Nation scooped them by coming out with this article, which really focused on primarily on President Ford's pardon of President Nixon, which the nation felt was a newsworthy event, thought should get out. But the court, looking at that and looking at this questionable nature or questionable character of how the nation had obtained the copy, and the fact that this work was unpublished at the time it was distributed or expression was used from it, and the fact that it had a clear adverse effect on the market for the work with time canceling the contract for that, even though it was a very small quantitative amount that was used, the court said, we don't just look under the third factor at the amount and substantiality used of the quantitative considerations, but also the qualitative aspects. And the court found that the less than 1% that the nation had taken was the heart of President Ford's work. Now, he might have been somewhat dismayed to find out that the heart of his work was less than 1% of all that he had written, but that would, as a result of that case, and something that we see often is when the Supreme Court does consider an issue, other courts mimic what the Supreme Court said for some time thereafter. And particularly since there was so much emphasis that the Supreme Court, Justice O'Connor wrote the opinion in that case, had put on the unpublished nature of the work, that really, in most cases after that, it wasn't until Congress actually changed the statute that this changed. Any use of an unpublished work prior to it having been distributed to the public with the authority of the copyright owner was typically not found to be a fair use. It went to such an extreme that Congress added a sentence saying the unpublished character of a work shall not decide the case without consideration of all the factors. So not to basically trying to readjust the consideration that all the factors have to be considered. So that is, under the second factor, that is an important one. That nation case also provided some information about the third factor, the fact that it's not just the quantity, but it also can be what the quality of what was taken. Although that can be somewhat of a misleading in terms of the qualitative use, because what you often find courts saying is, well, if they used it, it must have been important, therefore it must have been a heart of the work. So it becomes kind of a circular argument that you would say, in any case where someone uses it, it must have been important, therefore that works against you. Typically, the consideration, there is an important consideration about how much quantitatively it was used. And the smaller the amount that's used, the more likely, if it's for some transformative purpose, that that's going to be, that could be a fair use. And in some cases, like in the parody situation, it's actually more efficient to use the heart of the work because you're using quantitatively less to conjure up the original work. So the amount is an important, but it relates to the amount that of a work that's used has to relate to the first factor. You have to look at what was the purpose of the use, and then consider what amount is reasonable with respect to that particular purpose. So at least in a couple cases, courts have found that the use of an entire work could be a fair use. There were, at least in one of the situations that arose, was a Supreme Court case on, back in the days of the Betamax videotape machine. And nowadays I have to explain to my classes what a videotape machine and what a Betamax machine was. But the court found that the reproduction for time-shifting purposes of entire television shows or motion pictures that were offered over the air for free was a fair use. So that was the first time that a court had recognized the use of an entire work to be a fair use. And we tend to see those amounts come up in technological contexts, like in the case of a videotape machine and time shifting. Another situation is in the case of image search engines, which have found that showing thumbnail images of a whole photograph could be a fair use, because it really isn't, and part of the analysis could be that it really isn't taking the whole work, although you have a representation of the whole work. It's a degraded version of that work. And typically the search engine is going to be the most efficient way to direct someone back to the original source. So we see sort of a relationship between the fact that in the Betamax, the Sony case, that it was what was being copied was being made available to the general public for free and over the air. I think it's a similar situation that image searches, where it's something that's freely available over the internet through an open website, is something that for this transformative use that the court found to be the case, where you're organizing and helping direct people and helping people find images, that in that context, it wouldn't make sense to show the upper left-hand corner of an image. That wouldn't really help you a whole lot. But a thumbnail image that directs you back to the original source has been found to be a fair use. But then again, the use has to be put in perspective of what the effect on the market is going to be, and how will this affect the copyright owner, and more importantly, going back to the purpose of copyright, how will it affect the incentive to create? So if we look at fair use too broadly, so that people can just take large portions or important portions of other people's works without permission, a question will occur of to what extent does this undermine the entire purpose of copyright? So that's really where the balance of fair use comes about, because fair users, people who utilize other people's expression in a reasonable and transformative way, are creators themselves. And so we want a documentary filmmaker who's taking portions from motion pictures to make a different point is creating a new work. Or so there are many types of situations where fair use can actually be an incentive to creativity. But it's something that that people can feel very, very strongly about, particularly if the copying is done of their work. So that's why standing in the shoes is. And one case where this involving a novel was a novel was written, The Wind Done Gone, which was based on the characters and storyline of Gone with the Wind. And the estate had brought a lawsuit against the author of The Wind Done Gone, and ultimately the court found in that case, and this went to the 11th Circuit, found that the use in that case was a form of criticism or parody, in the sense that it was taking the characters in the storyline and showing that, or providing a different perspective of that story and of those characters, and looking at it from the perspective of the slave rather than from the slave owners. That was a controversial case, but I think it shows that it's something that that can be. Often there are disputes, and fair use is in the eye of the beholder in many cases, and it's difficult to know for sure where a court is going to come out on a particular issue. Often we see district courts come to one conclusion, the appellate court come to another conclusion, and at least in 3 situations, the Supreme Court reversing it again. So it can be a difficult determination to have a lot of assurance in, but an understanding of the factors, I think, is important. And we all, in terms of creating anything, there are recurring themes and things that are used in everyone's sort of consciousness, and that's something to be aware of too, is that from the perspective of copyright infringement, you don't have to intend to infringe. The courts have found that even unconscious copying, this came up in a case of George Harrison when he wrote the song My Sweet Lord, was found to have copied the chiffons, He's So Fine, and he really did not believe he had copied, and the court even credited George Harrison and believed that he didn't believe he had copied, but he had had access to that original work, and it was, the court felt it was probably somewhere in his mind at the time he created that work. So we all have these things that we're never quite sure whether they're completely original or whether there's some expression that's coming up, and in many ways some would argue there's nothing, very few things at least, that are wholly original. We're all sort of standing on the shoulders of giants and building on what came before. But now more than ever, given the duration of copyright, which is currently the life of the author plus 70 years, and you can't, nothing is in the public domain. You can't be sure that something's in the public domain and free to use unless you know it was published prior to 1923. So that's a pretty large, everything after 1923 that exists has to be assumed to be protected by copyright law unless you do some research at the Copyright Office, and the largest card catalog in the world, and which we're rapidly moving to put online. Can't be assured that that it is. You have to assume that it's protected by copyright law. So that's where these issues about fair use become more important in the creation of new works. And I'm happy to answer any particular questions anyone might have.
Well, thank you very much. Anybody have any questions for our speaker?
When a college professor takes 20 or 30 pages from a book and has the copy center copy it, and then the students go and buy it from the copy center, this seems very obvious infringement.
I missed the beginning of that.
Say a college professor has a reading list of things he wants his students to read, and he takes 20 pages out of one book and 30 pages out of another book and 10 pages out of this book, and has the university copy center copy it, and then the students go there and buy that to use in the classroom. That seems to me to be an infringement.
We haven't really had a case that goes back to the first article I wrote on fair use and photocopying, but there have been cases that have looked at that from the perspective of commercial copy shops, of Kinko's, or Michigan Document Services in another situation, another court case. And both have been found to have been infringed, mostly because they were commercial entities and could not be seen to stand in the shoes of the nonprofit educational institution. So part of the question might be, were that suit raised as to the course packs, of the nature of, was it being sold at cost, was it, how much was being used. And we have a recent case, the Georgia State, where it involved a digital twist on the course pack situation, where Georgia State had a policy allowing in sort of electronic reserves, or what many schools use various forms of sort of a secure course site, where only the students in the class can get access to the material that the professor puts up. Georgia State had a general policy about a general amount that would be considered to be fair use. A court had recently found that Georgia State's use was fair use, but there's some question whether that decision is going to get appealed. And it shows some of the difficulty in the fair use analysis in that it involved hundreds of works and different amounts of each work that were copied. And the opinion in that case is something like 350 pages long, where the court went through on work-by-work basis how much was used, what the purpose was, and so it can be very complex. But we at least have one case that recently decided that suggests that some amount that is copied and put in at the request of by the professor or by the nonprofit educational institution could be a fair use. On the other hand, if it's some kind of a commercial operation, they would typically have to go through something like the Copyright Clearance Center and get licenses for the use of the work.
Okay.
Yeah.
Hey, I have a question.
The only thing, I had a question, we're supposed to be out of here by around 2 o'clock. I promised the waiters so they can, maybe you could you ask him
Sure.
there so the waiters can come in and do, is
Sure,
that
that's
okay?
fine.
Yeah, great. You could ask him if that's okay, because I
Sure.
promised them there was a certain amount of time to use the room. So thank you very much. Thank you so much.